insights from recent cases in India. M&A has always been a matter of great interest to everyone, whether it's a young entrepreneur, existing businesses, or to professionals and other stakeholders. Post-COVID, I think propelled by various regulatory changes, economic trends, and evolving markets landscapes, there has been a considerable shift in the M&A landscape in the overall business. If you see large corporates like Holcim, SEC have been acquired, and large startups similarly on the same line. So there has been a lot of activities. There has been landmark cases under IBC in terms of acquisition and on various aspects. So today we are here to discuss some of the key issues, cases in the recent past that have affected the M&A landscape in India, and what are the key trends that are emerging and which will help you in guiding your decision of your restructuring your business, your company in times to come. And we have a very sound panel with us to discuss with. Starting with, we have the privilege of having Mr. Pradeep R. Sethi, former Honorable Technical Member of National Company Law Tribunal. From everyone at Corporate Professionals, I welcome you, sir, for giving your time. And we'll definitely be able to learn a lot from the wisdom that you will share with us today. Then we have from industry, we have Mr. Naresh Kapoor, Vice President and Head, Secretariat, Jubilant Bharatiya Group. He is having 27 experience in field of corporate law, securities law, and he would be joining us later. Then we have Mr. P. Nagesh, Senior Advocate, well-known advocate of Supreme Court, Delhi High Court. Then from our in-house team, we have Mr. Manoj Kumar, who heads the partner and head M&A and transactions. At Corporate Professionals have handled, I think, more than 400 M&A cases and advised both large and small corporate houses in restructuring their businesses. Alongside with him, we have Mr. Suman Kumar Jha, who works alongside Manoj and also is independently handling various M&A related matters at Corporate Professionals. He is also having a widespread experience in this field. And then none other than Mr. Pawan Kumar Vijay, founder at Corporate Professionals and past president at ICICI, who would also be joining us to sharing his wisdom. So we'll start the webinar by requesting the guest, Mr. Pradeep, to share his views, his wisdom on how he views that the shift is there in the M&A landscape. And then followed by Manoj and Suman's insight on the landscape and industry leaders' views on what is changing, what are the new opportunities that the M&A field throw all upon us. So without wasting much of your time, I'll now request Mr. Pradeep. Sir, I'll request you to, if you can begin the deliberations by sharing your wisdom on the topic.
Thank you very much. A hearty good afternoon to everybody. M&As, mergers and acquisitions, are two fancy words which create quite a lot of attention in the business newspapers and other newspapers also. Plus, they have the potential of causing quite a havoc in the stock markets also. So that way, it is a very good topic to take up today. Of course, I understand that for a merger and acquisition, it takes a lot of effort for two parties to come together. There are so many issues which are involved that ironing out those issues becomes quite a problem. But then when the broad parameters are agreed upon, then the next process which comes up is the legal aspect. Ultimately, the merger and acquisition has to be entered in the records of the Register of Companies by the Registrar of Companies, and that is also a very important step, because unless the legal acceptability is there, the merger and acquisition cannot go through. For that purpose, now there are three basic things which are there. The first one is that the application has to be made before the NCLT. The second step is the holding of the meetings, and the third step is the regulatory aspect. I will be concentrating on the regulatory aspect, but then what I want to say is that as far as the first point is concerned, which is the the application before the NCLT, before the Honorable National Company Law Tribunal, the affidavit has to bring out all the material facts relating to the company, such as the total financial position, auditor's report, and pendency of any investigation or proceedings. This is a very important matter because what the emphasis here is on all material facts. So that is what is going to determine whether ultimately the merger and acquisition goes through at the NCLT stage or not. And then, of course, the pendency of any investigation or proceedings. Normally, we find that in most cases, there is no pendency of any investigation or proceedings because that is looked after before the merger or acquisition is, the application is filed and after the merger and acquisition has been agreed to. Now, the next point which comes up is after that is that if the Honorable NCLT accepts the material facts, then a notice of meeting is to be issued. And that notice of meeting is issued to the creditors and it is also issued to the shareholders. There is a provision here for dispensing with this requirement of holding the meetings, provided there is provided a number of particular percentage files their consent. But as far as then the stage which also comes up is that a notice under the notice of the meeting is a copy has to be sent also to the central government, the IT authorities, Reserve Bank of India, SEBI, registrar, respective stock exchanges, official liquidator, Competitive Commission of India, and such other sectoral regulatory authorities which are likely to be affected by the compromise or arrangement. Representations are to be given within 30 days from the receipt of the notice. Here I would like to point out that as far as central government, registrar of companies and income tax authorities are concerned, the notice under section 235 is to be sent in all cases. Now, after the notice is sent, the particular authority can then file its representation. And there is a provision here which says that within 30 days, if there is no reply, then it will be presumed that no representation is made. But practically, what I find is that most benches do not take recourse to this, and they wait for the representation. Now, what happens in most cases is that the meetings have taken place, or the exemption is already there. But so a lot of time after that, everybody feels that now since everything is over, what is the delay before the NCLT? That delay is mainly because of the receipt of the representations from all these authorities. So that is one issue which is very important, which has to be looked into, and that is to expedite the replies from all these authorities. We find in certain cases that what happens is that the company gives us the details, but those details do not relate to the wrong jurisdiction, or they relate to the wrong office. So that is one matter which is required to be seen, that the details about all the statutory authorities and other sectoral regulators, those are collected accurately. Because if there is any delay, if suppose the notice is issued to a wrong office, so that office will forward it to the other office, or it may not even forward it. So it will mean unnecessary delay. So here, what I would like to say is that for curtailing the delay, that this is a very essential point. Now, then after that, then the issue that comes up is that we have to now go forward and see what sort of replies are received. Now here we have different replies that we are receiving, so that we can categorize into three parts. The first part would be those replies which can be easily replied to. Those are the ones which are easy to reply to. Little time is spent. That's all right. But the second part are those replies which require some sort of an action on the part of the company, but otherwise the reply is such, the representation is such that it does not affect the basic structure of the scheme of amalgamation or merger, and it is also not affecting the public interest. So as far as those particular replies are concerned, those take a little time, and then sometimes what we found was that that could have been looked into at an earlier stage only, and if a proper action had been taken at that earlier stage, then the requirement at this stage would not arise. The third would be those cases which are representations which are received, which are directly affecting the basic structure, the legal acceptability of the scheme, or are against the public interest. These are the ones which are the most important. Now, for that purpose, what I would like to do is that I would like to take up some case laws first, and then on that basis, then we can have a learning as to how to go forward for the future schemes. Now, the first case is of Sun Pharmaceutical Industries Limited. Just 1 minute, please. I think
Please take your time, sir.
Yeah, just 1 minute. Yeah, it started. Just 1 minute. Yeah, right. Now, just 1 second. 1 second, please. One more. Yeah, just one. Yeah. So this was a case of a transfer of two specified investment undertakings of Sun Pharmaceutical Industries Limited to two overseas resulting companies. Now, the regional director, Northwestern Region, filed its observations, and a few decisive observations were that Section 234 refers to cross-border mergers and amalgamations and not to demergers, and that Section 2 brackets 19AA of the Income Tax Act 1961 is violated, and the same will not amount to a tax-neutral transaction, and the company to make compliance with the provisions of FEMA and RBI. The NCLT opined that the provisions of Section 234 apply to cross-border mergers of Indian companies with foreign companies and vice versa, and the provisions mention only about the words merger and or amalgamation. So Section 234 do not provide for, or rather restrict, the demerger of the Indian companies with foreign companies. In addition to the above, it was also pointed out that Route 25A of the Companies, Compromises, Arrangements and Amalgamations Rules 2016 is silent on demergers and mentions only mergers and amalgamations. Moreover, it was stated that the Foreign Exchange Management Cross-Border Merger Regulations 2018 are applicable to the mergers and amalgamations of the Indian companies with the foreign companies also, and that the term merger, which was specifically contained in the draft regulations, was deleted from the final regulations. Well, I am not sure about what happened in the further appeal, but my own perception would be that that since Section 230 and 232 talks about mergers and acquisitions, therefore Section 234, to restrict Section 234 uh, to only mergers and amalgamations, and to say that demerger would not be included may be a little controversial. And as far as Rule 25A is concerned, the same thing is applicable, because not stating about demergers does not really make any difference. And as far as foreign exchange management, cross-border merger regulations 2018 are applicable, there again, the term merger not being specifically mentioned cannot be a final decisive factor. So for all these reasons, maybe, but it is a case which brings out the necessity of looking into the of it is a case which is based upon a more conservative interpretation of Section 234, and is therefore to be looked into in this manner. The second case is of Reliance Jio Infocom Limited and others. Here, the issue is that preference shares were cancelled, and preference share capital and the preference share capital and securities premium were reduced in such a way so that there will be constructive payment to the holders of the preference shares, and the constructive receipt of an identical amount as loan from the holders of the preference shares to the demerged transfer company. Now, this was since Income Tax Department was not present on the final date of hearing, the order sanctioning the scheme was passed. But against this order, the Income Tax Department approached the appellate tribunal, the Honorable NCLAT, and the main thrust of the argument was that the transfer company has sought to convert the redeemable preference shares into loans. That is conversion of equity into debt, which is not only contrary to the well-settled principles of company law, but would also reduce the profitability of the total income of the transferor company, causing a huge loss to the Income Tax Department. And then that there are two consequences of such conversion of preference shares into loan. Firstly, the shareholders who are now creditors can seek payment of the loan irrespective of whether they are accumulated profits or not. And secondly, the company would be liable to pay interest on the loans of its creditors, which otherwise it would not have to do it to its shareholders. And therefore, there is a reduction in profitability which is involved. And the payment of interest of such huge amounts of loan would lead to reducing the total income of the company in an artificial manner. But the NCLT held that the ultimate effect of the scheme may result into some tax benefit, or even if it is framed with an object of saving tax, or it may result into tax avoidance. It cannot be said that the only object of the scheme is tax avoidance. If the company has decided to have a particular arrangement by which there may be even benefit of saving income tax, that itself cannot be a ground for coming to the conclusion that the sole object of framing the scheme is to defraud the Income Tax Department or other tax authorities. And then the Honorable NCLAT held that the mere fact that a scheme may result in reduction of tax liability does not furnish a base for challenging the validity of the scheme. Hence, the nod to the scheme was granted by NCLAT. Now, here, this is a decision which clearly brings out that what has to be seen in a scheme is whether that scheme is legally acceptable or not. It might have some consequences, but whatever, and those consequences, if they are of taxation, are they of such a nature that we would come to the conclusion that they are affecting the basic structure of the scheme, or they are affecting the public interest? So this is an important decision that way, in which the Honorable NCLAT has taken a reasonable view and has held that even though there may be tax avoidance which is involved, but that by itself would not be a determining factor. Again, there is another case of Minda TG Rubber Limited and others versus DCIT, in which a scheme of amalgamation was, in which the Income Tax Department raised an objection that there is no undertaking filed regarding the fact regarding the fact that as per the provisions of Section 72A of the Income Tax Act, the transferring company shall not dispose all the assets and shall hold at least 3/4 of the book value of fixed assets. Here, what has been done is that the matter had to go to the Honorable NCLAT, which allowed the appeal after an undertaking was submitted by the transferring company. Now, this is what I was trying to point out earlier also, that these matters, if they are looked into at an earlier stage, and this undertaking was submitted at an earlier stage, the complete process would have been expedited. Now, there is one case in which the Honorable NCLAT has held that the scheme is not legally acceptable, and that is in Bank Street Securities Private Limited versus Regional Director. Here, the order of the NCLT was upheld, and there was an application of amalgamation of 8 companies into the 9th company, and it was held that the necessary approval of the RBI and the scheme of arrangement was not sought, even though the certain companies involved in the scheme of arrangement were carrying on with NBFC activities, as the financial assets of those companies were more than the non-financial assets, and income from operations was zero without this breakup between financial income and non-financial income, and hence approval of the RBI was required. Here, this is what I would like to emphasize once again, that this was something which should have been seen at the earlier stage, so that all the effort which was put in the proceedings, that could have been minimized. Now, as far as the Competition Commission of India is concerned, the issues which are there are that if the competition is sought to be, if the arrangement is such, the scheme is such that the competition is sought to be reduced, then in that case, the Competition Commission of India does not normally give any approval. But what has been done in most of the cases is that the parties have agreed to a voluntary structural remedy or some other matter, or they have decided to hand over a part of the decision to make a divestment, so that the necessary approval from the Competition Commission of India is obtained. Now, in an interesting case of Reckitt Benicayser India Private Limited versus RB Hygiene Home India Private Limited and others, there was a scheme of demerger in which the payment was to be made by a third company, Hi-Ho Hold Company, and the payment was to be made through shares. Now, the issue was that whether the consideration can come from a third party or not. Here it was held, the NCLT held, that the issuance of the shares by the holding company, which is not involved in the demerger of one of the business of the company into the others, is a valid consideration. So here there is an interesting decision which says that the consideration for the demerger can come from a third party also. So now, coming to the final conclusion. So the learning we get is that as far as meetings are concerned, exemption is available, but for the regulatory responses, there is no exemption. So even though there is a provision of presumption, but that is not being generally utilized, so therefore it becomes all the more necessary that the regulatory aspect is given due consideration, so that the proceedings are expedited before the NCLT. Second, the regulatory comments can be categorized into 3 parts. no comments, oblique comments, which can be easily replied. For example, there is some demand due, and their undertaking is given that the demand will be paid. And then the second part would be comments which do not affect the very basis of the scheme and do not result in interpreting the scheme as being against public interest. For example, conversion of redeemable preference shares into loans, and then the compliance of provisions of Section 72A of the Income Tax Act 1961, which I discussed earlier. Now, the third one is the one which is most important, and that is the comments affecting the very basis and legal acceptability of the scheme. For example, approval of RBI not obtained in the Bank Street case. So, while preparing the proposal, the following points are very important. The first point is identifying regulatory authorities properly with their proper addresses and proper jurisdiction. The second one is to do some brainstorming and identify the possible queries. Then third is to think about the possible replies and take action in advance. And the fourth is to identify possible contravention oblique revenue implications under other statutes and take advance action. This is most important because because even if the approval, because there is no non-obstante clause available in Section 230 or Section 232, and therefore the effect of the merger or acquisition on, as far as some other statute is concerned, that consequence has to be taken into consideration. Thank you very much for a very patient hearing. Thank you.
Thank you, sir, for sharing your wisdom. I think the case laws that you referred were very insightful. Sir, any key challenges that you foresee companies generally face while submitting their M&A applications? Any key precaution that you would like to highlight apart from the points you raised?
No, key precaution is the key precaution is this only what I was talking about.
Okay.
That first of all we have to divide it into three parts. The first one is the filing of the application, which is the most important part. And there, as I was saying, it's the non-disclosure of material. It is the non-disclosure of material facts which will cause a problem. Of course, as I was saying, the investigation and the proceedings aspect that is normally looked after. Now, as far as the second stage is concerned, conducting the meetings, normally after the notice is issued, after the notices are issued, the meetings are conducted. Normally, there is no problem there. Of course, sometimes there is a problem in determining the exact quorum and also the exact and also those who have voted in favor and against. There some problems do come up, but those are minor problems. The major delay which occurs after that, because then by that time everybody thinks that the matter is now over, but then the regulatory aspect comes in and that causes a problem, that causes delay. That is what we have to see at the first stage only. How do we get over this aspect also? Of course, one very important point, according to me, is that whenever any proposal is made, whenever any scheme is developed, the first thing to see is what is going to be the effect on other laws. If that effect on the other laws is taken into consideration and the scheme is developed in such a way so that there is no contravention of any other law, no revenue implications are involved, then it will pass through. But as far as proposals, as far as schemes are concerned, so normally what I find is that in most schemes, the comments we were getting were minor comments only. But it was only the delay which was the most, and that delay was also being caused in certain cases because of small matters only, the jurisdiction, for example, or the office, for example. They give a notice to a wrong office, it will not reply to that notice also, so you're caught up. You have to again find out where to give the notice again. That again takes another time because you've got to give the specified time period has to be given. So the hearing date will then get postponed. So this is one basic problem. Otherwise, as far as mergers and acquisitions are concerned, of course, there are very few cases. There were one or two cases which came before us in which objections were raised by third parties also. But those are very rare cases. In that case, the objection was raised by a third party. In one of the cases, the objection was raised by the third party, saying that a technology is sought to be transferred, but I am the owner of that technology, so it cannot be transferred. That we had to decide that matter. So those are matters which come up. Yes.
Sir,
This high-ho matter also, which I was just speaking of, that also came before us only. So there also the issue was that is that in normal cases the concentration is moving between the companies to the amalgamation only. But here it was moving from the holding company. So there again we had to take a decision. So those are exceptions, but those are exceptional matters. In most matters, it just goes through. It follows. In most matters, it is only the procedure which is being looked into. That is what we have to see. At the NCLT level, what we were seeing at that stage is that the procedure is correctly followed. There is no defect as far as the procedure is concerned, and that is what is basically required.
Sir, you mentioned about delays, and as a former member of NCLT, I would like to have your views that these days the mergers, M&As are taking a lot of time to process, to finally get the approval. At times takes 8 to 12 months. So, do you see that judiciary is overburdened, or there you see some regulatory changes that are necessary to make sure that the process is expedited a little bit?
Because as far as the process is concerned, it takes its time, especially when meetings are conducted. Where exemption is granted for the meetings, there it is much faster. But as I was saying, after that, because at that point of time, then we think everything is over. Now, not everything is done, but then the regulatory replies do not come. That holds up the whole proceedings.
So, sir, shouldn't there be any timelines? If regulatory replies are not being submitted, then NCLT can proceed ahead.
No, I already told you. That is what I already told you, that there is a provision which says that if within 30 days there is no response, it can be presumed that there is no representation. But most benches, this is my own experience, that most benches of the Honorable NCLT do not accept such an interpretation.
Yes, that is
the basic problem. That is the basic thing. Of course, it is there very much. But that is why I was saying that as far as the provisions are concerned, there is nothing much that can be done about it, because the provisions are quite straightforward, and I think they've stood the test of time also, and there's not much of a problem there. But the problem comes only at these stages. Yes, of course, after the COVID, there has been a substantial increase in dependency in all courts, including NCLT also, contributing to the problem.
Okay. Thank you, sir. Thanks for sparing your time. If you have more time, you can stay with us, and there will be some Q&A at the end, and you can join us in replying to the queries of the Delhi participants. I'll now move on to Manoj to share his presentation or whatever he wants to share in terms of the topic, and then we'll take it to others. I think Mr. Pawan has also joined.
Thank you, Ankit. Ankit, I think Mr. Vijay has joined, and he is because it is traveling. I think it is better if you can call him first before me, and so that a conversation can happen.
So, sir, Pradeep sir has shared his views. I believe you must have heard some aspect of that.
Yes. So, Ankit, thank you very much. I just because this is one subject which is very dear to me, and as you are aware that in India, all corporates are in a new business. One is business, and then second is structuring. Now, what is happening? That there are two aspects are very popular nowadays. One aspect is that demerger. Now, various companies are having big business. They want to structure it, because what is happening when license Raj was there, when various business you were doing, so in the process of business, the compliance was not that difficult. So people have formed the company and they have doing business in the same company. That time the investment was also not very attractive, and the people were not investing in a specific industry. So what happened? The people made the company and they were doing business in the same company. Now they realize that interest of investor is not same. They are interested in specific business. So today, under one business company, multiple business is giving a less valuation, and that's why there's a new era has started of demerger. Recently, we have seen Reliance. So Geo, they have separated. We have seen the ITC, they have done the hotel business separate. ITC has a hotel business separate, but long back they have merged with ITC because they were thinking that they should have one business. But that you can realize that first everybody was consolidating. Now everybody is interested to no consolidation, but a separate business of separate industry should be in separate entity. So that is one happening. Second, which is biggest thing, which is a part of which I have told you, license Raj, when you can't have a big company, multiple company, and under the business, you are getting an opportunity and some partner is there, somebody is there, you are making company. Real estate company, you can't have a land more than this. So every business house has created multiple entities. Wherever their business, they formed the company. So they have never seen this, that what will be the impact of this particular thing in future. Because today in a company, you have a 20 company, 15 company, 18 company, 100 company. Real estate company has a 300 companies. But today these companies are, which is not very, they're not value adding anything. And the compliance level, the way it has come out, which is not only the specific company, but multiple companies multiplying with each other, relationship with each other, related party transaction. All these things have created a big fuss now, and a era of demerger is for different purpose, and this consolidation is for different purpose. So they are planning to merge non-related business. They are planning to hive up the business. They want to merge the business and they want to consolidate it. So this consolidation process is going on, and you will see more and more company will start doing this. And in our clientele, when we talk to our client, it is first thing is coming that how to do this. Today I had a meeting with one client. They want to bring out IPO. So the IPO era is also taking shape. So in the IPO era, one important thing is there, how efficient your structure. If your structure is efficient, you'll get better valuation. If your structure is not efficient, you will not get valuation. Another aspect is there, sometimes you have a two business, equal business. One has a good market P and second has a bad market P. So if you combine, it's not that you will get a combination. Always it is happening. The lesser P is the combined valuation of the company, which investors are normally doing. So that's why if you want to have a better P, you discontinue or demerge the company. And if you have a various multiple small company on the same business, you consolidate. So the consolidation process has started. Lots of companies are doing. If you are going for IPO, which I just told you, the IPO is one important thing, that you cannot go to IPO with multiple companies because you have to give explanation of each and every company, their case law, their subsidiary status, their associate status, and various things will be there. So the consolidation era has started and people are following. And I hope that these two changes will be the part and parcel of the business now. And when somebody is starting business, they are asking, earlier they were doing business and then they were facing problem. Now they are starting anything. They are seeing what will be the future, how I can use this company, whether I have some group company which I can use. That thing has started. And it can reduce cost. it can make more efficient system, and it can work out in a better manner. So this is my point of view for this restructuring. Over to you, Ankit.
Thank you, sir. Thank you. I think you can. You also talk a lot about leaning of structures.
Yes.
You also can share your views.
So leaning of structure is always advantage because we have one product of leaning of companies. So what we are advising to the corporate, that why the point is why you have a multiple companies, and then we give the example of if you have a company. So the process is very simple. So if you have a company, if you have a group, so you must follow. You write down all the company's name. Just see that why this company I require, and see this whether this company is doing any business or not. But compliance you have to do for every company. You have to appoint auditor, you have to appoint, you have to file the tax return, you have to file the balance sheet, you have to file the company law compliances, you have to file various things. So the difference is not there. Only thing is difference is the quantum of work, but you have to follow entire thing. So first you jot down all your company's name, identify that whether they have a business or no business. Sometimes you are having a business because of the name is there. Sometimes you have a business because you have some future plan. So name, there are multiple things. There's no need to keep the company. You can save the name by other process. You can register the trademark and then you can use. So the identify the list of the company, see whether they have a business or not, and then see the same type of business. Can the same type of business can merge at one place and becoming a big, and then some companies which are not relevant, you can sell it off, you can close it, you can hive off it also, and you can do something. You can strike off or you can close it. Voluntary liquidation you can go, but keep those which are active company. Today you want to make a company, it take 1 day, 2 day, 3 days, 4 days, and you can get your company registered. So it is not a big issue. So leaning of companies can reduce your cost, reduce your headache, reduce the compliance burden, reduce unintentional problems of the company, of the compliance issues, and you can save lot of money. And the consolidation of things can help. You formed a various company creating authorized capital. Now as per the merger law, you can merge the authorized capital also. That can also save. But ultimately you have an efficient system in your house and you can run better, not confuse with multiple entity without any use. Over to you, Ankit.
Thank you, sir, for touching upon that point. I'll now request Manoj to discuss his views on the topic.
Thank you, Ankit. So I think good evening, Honorable Mr. Sethi, Pawan sir, and all other panelists and participants. This is a very interesting topic, as Ankit has always said. M&A and transactions are always very interesting and very complicated also, and a lot of things involved in any such process. So and it is also very important milestone in the life of any company, because M&A transactions does not happen on daily basis in any corporate house, and so it is very important to plan it very well first and then go for its execution. So I would in this today's session, first I will discuss about the basic planning and structuring. What are the reasons for which company go for M&A transactions, and then procedural aspect would be covered by my colleague Suman. Right. So to just let me share my presentation. So if we talk about the planning and reasons why most of the company go for M&A transaction or corporate restructuring transactions, there are three major heads. One is inorganic growth. So many of the company would like to grow faster, through let's say brownfield project in case of manufacturing entity, or let's say there may be a situation where they want to enhance their capacity and some company is available which has the capacity which can be consolidated into this company. There may be a need for increasing the size of the financial or manufacturing capacity, or manpower based size enhancement can be one of the reasons why the company is going for this merger or amalgamation strategy. Then there may be certain financial strength which may be increased due to merger or amalgamation. There may be a need for geographical expansion, and hence there is a target. Let's say one company is operating in the north of India and another is in the South India or West India, and merger of the two company may enhance the geographical footprint of the organization. So that may be one of the key determining factor for going for a merger. Similarly, there are definitions of, let's say, vertical merger or horizontal merger. So vertical mergers are those where supply chain, under the supply chain of a company, one company is output of one company is the input of the another company, and if these two are consolidated, there may be very high cost reduction. So that can be a very good strategy for amalgamation or consolidation. This is called the vertical kind of merger amalgamation. Then there may be regions of diversification for a company also. Let's say there is a technology which is getting absolute and a new technology is emerging. And so considering the future aspects, organization may decide to go for expansion into a new line of business, or line of business which is a bit different right now, but in longer run would be help to survive in the good. So these are the major reasons of inorganic growth planning for which mergers, acquisitions happen. So merger and acquisition, there can be two type of things. Mergers are those where regulatory aspects, regulatory process creates single entity. One entity loses its existence, another entity continues as a single entity post merger or amalgamation. Whereas acquisitions are a different strategy where existence of both the companies continues, and it may be a holding subsidiary structure, or it may be wholly owned subsidiary structure, or there may be acquisition of some business or division of another company into this company. So this is called acquisitions. In case there is a listed company involved, there may be a requirement of SEBI takeover regulations which need to be followed. So that will be a part of the strategy of acquisition. The second limb of planning is relating to unlocking the value of a business. So unlocking can happen through demerger, where a company is split into two or more companies. If single company has more than one type of business, like let's say a company is doing power as well as steel and power. So planning can happen to divide steel business and power business separately. Recently, there is a spurt of demergers. So we have seen many of the cases where demerger happened, like Piramal Industry. Piramal Industries was a very old company and it was growing faster. Slowly, they have accumulated funds, and those funds were invested into many of the market instruments, or other companies' financial instruments were acquired by the company. So they have decided to hive off the finance and investment division from the main manufacturing company. So manufacturing pharmaceutical company became a separate listed entity, and the financial company is now a separate listed company. So this kind of demerger activity is going on, like like Pawan sir was talking about the demerger of ITC. So ITC has decided to hive off the hotel business from its FMCG, food products, and IT, cigarette, etc. So they have various business divisions, and now they are separating the hotel business because it is they believe that this is a totally different kind of business and need focus now. So reason of hive off or demerger may be to create more focus on one kind of company, separate type of businesses, different leadership structure may be created, and they can lead it to further growth. There, in such kind of demerger activities, in most of the cases, unlock the value of the entity or business which is not getting the key focus if it is a consolidated entity. Similar thing happened in case of Reliance industry, which has hived off the Reliance Financial, Jio Financials, and it became a separate entity, and both are listed now. So these are the two inorganic or growth strategies. But the third one is basically the internal simplification of the group structure, which I think Pawan sir was talking about, the leaning of the group structure. So it may be corporate restructuring where multiple subsidiary holding companies are there. So those entities are consolidated into one entity. It can happen through merger, amalgamation, or reduction of capital. So there may be different strategies. One is reduction of number of entities, reduction of complexities, and removes the non-required entities in the group. Then it will also simplify the shareholding structure. So there may be cross holdings among the companies. So those cross holdings may be separated. Maybe if the merger happens to the group companies, then all those shares goes directly to the end shareholding entity or end beneficial shareholder, so that there is a simple structure. It will also help in long-term succession planning, family succession planning, because the holding goes to the individuals who are the real beneficiaries of the group. So that kind of structuring is also very much prevalent these days. Now we will. I would like to discuss a few recent cases of such strategies, and what are the benefits it has created to the organization. So first, going for the inorganic growth strategy and their benefits. So we have seen recently there was a merger of there is a well-known merger of HDFC Limited, which is the main holding company earlier, and the HDFC Bank Limited, which is a private sector bank. So these two entities got merged into each other, and there were also several other intermediaries, small subsidiaries. Those were also consolidated into HDFC Bank. The end result is that there is a mega company which is having the retail banking as well as housing finance business, and it is now India's largest private sector bank. So its profit has grown substantially, its market capitalization has grown substantially. There has been a lot of internal technology overlap of the employees, which has now reduced. So those reduction of overlaps, etc., has caused substantial gain in the value of the company, strength of the company, and the market capitalization of the company. So it is a win-win for everyone, including all the shareholders and creditors of the company. So this is a very typical example of consolidation and inorganic growth strategy which has happened. Similar, I think I have already discussed, there has been many other cases like PVR and Inox, two mega multiplex companies of India got merged into each other. And now it has created the largest multiplex group in India, having more than 1,500 screens all across the country. We have also seen Adani Group acquiring Ambuja Cement and its subsidiary ACC Cement. So by consolidation of these three entities, now Adani Group is the second largest cement manufacturer in India after this Aditya Birla Group. So recent news, we all have heard about the merger of Sony TV and G Entertainment. So G Entertainment is a listed company, whereas Sony is worldwide large, very big entertainment and media company. So these two are getting merged. The process is almost complete, and by consolidation, the financially weak G is now getting very much growth, and it's growing very fast. So these kind of strategies always help in growth of the organization, growth of the group. There may be some cases which are very unique, like Adani Group acquired NDTV, right? So it is an acquisition which is not directly connected to the existing business of the company. So the purpose is to diversify into the new line of business, and that kind of a strategy is also very much prevalent. So recently, this kind of consolidation also happening through the schemes of insolvency resolution process. So like we have seen, Tata has acquired Bhushan Steel, which is having very big manufacturing capacity for the steel business, and that consolidation has given a lot of export to the size and volume of the business of Tata Steel. And post acquisition of this company, they have also consolidated by merger. So that kind of strategy is also going on. We have also seen the report of IBBI, which says that in case of manufacturing company, the success rate of resolution is very high. That means people or companies are using it as a growth strategy to acquire existing capacity of the insolvent companies and through which they are growing very fast. Besides going through the process of creating a new, putting a new plant or new manufacturing facility, they are acquiring the existing facilities which are available and which are available at a cheaper rate in case of insolvent companies. So they are acquiring and then they are consolidating those entities. So this is a very good inorganic growth strategy, and many of the corporate houses are using it. A few examples of or case studies relating to unlocking of value through demergers. Like we have discussed the demerger of hotel business by ITC. So this is a complex kind of structuring. They have not created it is a parallel entity, but they are creating a company which is which will be having shareholding in the hotel business also. So the entire business of hotel business of ITC Limited would be hived off into another company, which is ITC Hotel Limited, and the FMCG, cigarette and agri and IT business would remain in ITC Limited. But in consideration of this demerger, all the shareholders would not get 100% shares in the ITC Hotel Limited, which will be a separate parallel listed entity. But 60% of the equity shares of ITC Hotels would be with all the shareholders of all the public category shareholders of ITC Limited, and 40% would continue to be directly owned by ITC Limited. In this manner, ITC would also get 40% value of ITC Hotels in a longer run, and shareholders would also get the benefit of liquidity in the shares of ITC Hotel. They can sell in the market after listing of this. So there will be direct stake of existing ITC shareholders in a pure play hotel entity, and there will be independent market driven valuation of this new entity, which can be used as an investment tool or as for liquidation and raising funds. Then there will be cross synergy, because 40% will continue to be owned by the ITC Limited. So this is a very complicated but unique kind of structure, and I think this kind of structure was also held in past by the Bajaj Group. They have also hived off their different entities and kept certain holding in the main entity. Then we have also discussed Reliance Industries hiving off Geo Finance business. So Geo Finance business was a internal vertical, a small vertical, where they have deployed their financials over a period of time, but now they wanted to focus it on full-fledged investment banking business, non-banking finance business right now, which may in the longer term can be a bank, a full-fledged bank also. So under this planning, they have hived off Geo Finance as a separate entity, where all the Reliance shareholders got 1 share against 1 share of Reliance Industries, and the company Geo Finance is now listed on BSE and NSE. So this is a separately listed. The value has got unlocked. We can see just before the transaction, the market cap of Reliance Industries was around 15 lakh crores, whereas post listing, Geo Finance got a valuation of 1.4 lakh crores, and the market capitalization of both the entities collectively is around 17 lakh crores. So obviously we can say that certain portion will be organic growth in the market cap also, but both the companies are totally differently listed, separately listed, and the shareholders are owning shares in both the entities. So they can dispose of, let's say they are not interested in the finance business, they may dispose of the shares and raise the fund. So this kind of planning has helped in the increase the confidence of the investors also, and has helped in growth of the company. And then recently we have seen announcement of demerger of Vedanta. Vedanta is a basically multi-business entity, Vedanta Limited, and it has iron and steel, zinc, aluminium, mining business. Then they have power business, oil and gas business. All those entities are now getting, all those business units are getting demerged to 6 different companies, which all are right now a wholly owned subsidiary. Basically, SPV is created just for the purpose of this demerger. And through this demerger, they want to create 6 separately listed entities. So the shareholders of each of the of Vedanta Limited would get shares in all of the 6 companies, and they all will be listed and generally traded. So this will also simplify the group structure corporate structure, and investor would get value in each of the entities. There may be a separate class of investor interested in power and mining. So mining shareholder interested investor may dispose of holding in power sector entity and continue with the mining sector entity. This kind of flexibility would be available to all the shareholders. If we talk about the simplification of group structure, there has been several such cases. One case is many of the companies within the group of Wipro Limited, within the framework of the brand of Wipro Limited, got merged, consolidated into one entity, and the rationale was to basically rationalize the subsidiary number of subsidiaries, reduce the multiplicity of the compliances, broader portfolio of service to be available to all the customers of Wipro Limited, then concentrated and focused management. So having multiple business entities within the group or within the framework always creates compliance hurdle as well as business strategy hurdles. So the top management has to focus on the growth of each of the companies separately. Whereas if they all are consolidated, it helps to management to take decision faster. There may be certain cost savings also relating to duplicity of certain manpower, which are only because of the creation of different entities. So this is also a very common strategy these days, and like we have seen a scheme of amalgamation of several companies being filed by Mahindra and Mahindra Group recently. Then there was a merger of 5 companies, group companies, by Welspun recently. India Bulls has filed a scheme in which 17 different companies of the group have been put to consolidate into one entity. Similar scheme was filed by Oberoi Limited, and they have consolidated 4 group entities into Oberoi Realty Limited. So these all are the same planning. They want to simplify the structure, create larger entities, single larger entity, to avoid duplicity of management focus, to avoid cost, to avoid compliance hurdles. And these are the few examples of the listed entities, but there are hundreds of unlisted groups in India which have thousands of companies within their fold, hundreds of entities in each, and many of the companies are not acting at all. So, but they are in existence. They are putting a lot of pressure on the management to comply with the things, to work, to use them for certain purpose or not. So a merger amalgamation of those entities would be a very useful tool to simplify the structure. So I think broadly, these are the 3 reasons of or planning reasons why a company or a group goes for corporate restructuring or amalgamation or mergers. First one is very well known, that inorganic growth strategy that I think I have discussed and given examples also. Then another is, which is very common right these days, is the demerger. I think sir has also told that demergers, removing different kind of business from one group, one entity, always helps to unlock the value of a company which are not getting with the business, which are not getting focus earlier. So, and then the third one is the leaning out of the group structure, creating simple structure, lean structure in place of complex web of shareholding among each other, and where it is difficult to determine who is the owner, who is the controlling person, which in longer term very difficult to help in succession of the organization or group. So that strategy is also going on. So I think I have covered the legal planning part. Now I would request, I think Suman would be able to go through the process of merger, demerger. What are the legal requirements, how it is being handled, what are the complications, etc., etc. Thank you.
Thank you. Thank you so much for sharing your insights on so many restructuring plans that have been in line recently. And I think now as you mentioned, let's move on to Suman for his insight on the legal processes involved in terms of the entire exercise. And then we'll, if the industry experts join us, then good. Otherwise, we'll move on to the Q&A session.
Thank you, Mr. Ankit Singh. Good evening, everyone. So I'm taking regulatory aspects of M&A, wherein I will discuss the regulatory hurdle which is coming during the course of merger and acquisitions. Right. So next slide, please. So if we will see the framework governing M&A transactions, so these are the framework like Companies Act 2013, which provide procedural aspects of merger and amalgamation. Then Companies Compromise Arrangement and Amalgamations Rule 2016, which deals with the NCLT procedure, wherein we are filing the application before NCLT. What are the criteria which we have to see? Then SEBI Master Circular, it applies in case of listed company. Regulation 37 also apply in case of listed company merger amalgamations. Then Stock Exchange SOP, it is also applicable in case of listed entity merger amalgamation. Then Rule 19(2)(b), and this is basically this apply in case of reverse merger and demerger, listing of companies during the process of demerger. Then Part E of SEBI, Schedule 6 of SEBI ICDR regulations, basically it applied in the case of merger, wherein unlisted company getting merged into listed company. So if we will see the Companies Act, then basically Section 230 to Section 236 provide for the merger and amalgamations, wherein Section 230 to 232 deals with the merger and amalgamation filing NCLT route, and Section 233 for fast track merger. So step we will see on next slide, but Section 233 I would like to deal here only. So Section 233 provides a process of fast track merger. In case of Section 233 merger, we have to file the application before RD, Regional Director. And the most important thing while we are filing the application under Section 233 is declaration of solvency. So first we have to see that both the companies should be, net worth of both the companies, transferred as well as transferee companies, should be positive, so that the company can give the declaration of solvency. So rest other part, like where in case of 232 merger, we have to convene the meeting as per instruction of NCLT. In this case, we convene the meeting, and if shareholders approve the merger, our scheme of arrangement with 90% majority, then majority in value, then it will be considered as approved, and then we are filing the application for approval of Regional Director. So only transferee company has to file the application for before RD for approval. Transfer company is not filing the application in this case. And rest, once we are filing the application after approval of shareholders, RD is suggesting the observation of registrar of company, official liquidator, and then on the basis of observation of the regulators, RD is approving the same. Now SEBI master circular, which govern the merger of listed and unlisted company, it is there are many conditions in this circular, and this circular is very important while we are planning for merger between two listed entity or merger of unlisted company with listed company. Like few key points I'm going to tell you, that when any for example, when in any unlisted company getting merged into listed company, then the financials should not be older than 3 months. When valuer considering the financial for valuation, both the company's financials should not be older than 3 months. And the financial of listed company may be with limited review, but the financials of unlisted companies should be audited one. And while valuer applying the valuation methodology, all the three methods like income approach, market approach, and asset-based approach, these are the methodology which should be the valuation should be carried on the basis of these three methodology. Then once the board approved the scheme of arrangement, then within 30 minutes we have to intimate the stock exchange and disclose all the mandatory disclosure as per the SEBI circular, right? Then once board approved the scheme of arrangement, then within 15 working days, the listed company has to file the application for the approval of SEBI and stock exchange. And one of the most important part is that the valuation should not be older than 7 days. prior to, like if board meeting is today, then our valuation report should not be older than 7 days. In case if this timeline will be exceed, then that valuation report will not work. Then once we will give the scheme and other necessary document for we will file the scheme and other necessary document for stocks in SEBI approval. Then the few major thing which SEBI and stocks in overview, like the company has to undertake that when the valuation has been carried and the scheme has been filed with the stock exchange, there will be no impact, there will be no major financial change has been occurred in the balance sheet of the company, so that the share exchange ratio will remain same. If there will be any major changes, then that valuation report will not work. Then audit committee has to ensure that there should be proper rationale behind the scheme of arrangement. Cost benefit analysis should be there. What are the impact of the scheme of arrangement on the shareholders, investor? So audit committee has to give the report, and same report has been given by the independent director also. So while we are planning for merger amalgamation between listed and unlisted entity or between two listed entity, we ensure that yes, financial should be at the earliest possible date, even audited financial. Now, like Rule 19(2)(b), as I told earlier, that this is the rule which applied when any company, through the process of demerger, getting listed on the stocks on same stock exchange. So all the process are same, but in this case we have to after the observation letter issued by stock exchange and after the NCLT approval, we have to file 92(b) application. And the major one of the major document of this 92(b) is information memorandum. So in information memorandum, we have to disclose all the aspects which is provided in ICDR regulation, but we have to comply. When SEBI and stock exchange issue observation letter, they are giving certain conditions, certain clause, which should be part of this information memorandum. If any of condition, any of clause, we will not put in the information memorandum, then definitely SEBI and stock exchange will take it very negatively that you have not shown it properly. And as I told you that Part E of Schedule 6 of SEBI ICDR regulation deals with average prospectus. And in case of merger between listed and unlisted entity, we have to disclose certain information on behalf of unlisted entity. And this should be certified by the merchant banker also. And most important part of it that this average prospectus will be part of notice and explanatory statement. While shareholders and creditors will approve the scheme of arrangement and will read the notice and explanatory statement, they may take informed decision that these are the fact of unlisted entity. Please move next slide. So as we have discussed the regulatory aspects, so these are the challenges which are coming from the basically regulatory side. So concern of statutory authority like RD, ROC, stock exchange, when we are filing the scheme. Taxation aspects, what are the concern of income tax department? As Sethi sir already informed that how National Company Law Tribunal considering the application and what are the points which we need to take care. SEBI and the stock exchange I have already discussed. Competition Commission of India, and one of the most important aspect, stamp duty aspect. So concern of statutory authority, while once like stock exchange, in case of listed company, stock exchange approve the scheme of arrangement, and within 6 months of observation letter, issuance of observation letter, we have to file the scheme before NCLT. Then NCLT will give the direction to convene the meeting, and once shareholder and creditors will approve the scheme of arrangement, then we have to send the scheme to the regulators for their observation. So in many scheme, what I found that many times RD and ROC observing that yes, the appointed date is antedated because it is 1 year or 1.5 year old. So this is old date. Now it will not work. So MCA, there is MCA circular on it that if there will be proper rationale behind it, then the appointed date can be 1 or 2 year old. But ROC and RD generally objecting it. Then taxation aspects. So while NCLT giving instruction to serve the notice to income tax department, then income tax department usually see that the condition first they are looking that the scheme should not be instrument to get the tax benefit only. They used to check that whether a scheme is qualifying the section 2(1)(b) of Income Tax Act and 2(19)(a) of Income Tax Act or not. If the scheme will fulfill the criteria given under section 2(1)(b) and 2(19)(a), then they will give the NOC, and not the only that point of time. They if there is one provision in an Income Tax Act, then when a loss-making company merging into profit-making company, then there is provision of transfer of depreciation and tax under section 72A, carry forward of losses and depreciation. So they also check the whether all the conditions of 72A is complying by the company or not. They also try to find in the scheme that whether the clause which mentioned that all the legal dispute which is before the income tax department will be carried on same term and condition against the transferee company. This clause is not is mentioned in the scheme or not. Whether this clause that any tax liability which is in the name of transferred company will be paid by the transferee company or not. Whether this clause is mentioned in the scheme of arrangement or not. So these kind of thing. And after that, nowadays, what I found that income tax department also asking to submit indemnity bond, that if there will be any future tax liability on behalf of transfer company, whether the transferee company will dispose this tax liability or not. So these are the things. Now SEBI and stock exchange concerned, I have already mentioned that when we are filing the scheme of arrangement, then basically SEBI and stock exchange first they check they have SOP and they have master circular. They check all the conditions, all the documents, whether we have submitted all those documents. There are 35 documents which we need to submit before stock exchange and SEBI for their approval. But the major thing nowadays which SEBI and stock exchange looks that what will be the impact of merger amalgamation on the public shareholders, whether the scheme of arrangement will be beneficial for the public shareholders or not. What would be the impact on net worth? How the after merger, how the business will be affecting of transferee company. So these are the thing now. These are the major points which SEBI and stock exchange look. Now, I would like to tell you that Competition Commission of India also nowadays very active, and almost in all the cases NCLT, when we are filing the application before NCLT, so NCLT almost in all the cases giving direction to issue the notice to Competition Commission of India. So for approval of Competition Commission of India, there are certain limit is there. However, when we are filing the application before Competition Commission of India for their approval, but in case they are not giving any observation within 30 days, then we used to submit an affidavit before NCLT. And in Regulation 9, there is one provision, exemption is there, like in case of holding wholly owned subsidiary, in case where the shareholding, majority shareholding, more than 50% shareholding in transferor and transferee entity is in the hand of same promoter shareholders, same shareholders, then in that case, there is no need to file the application before Competition Commission of India for their approval. But there are cases where Competition Commission of India have given their clear view that the role of Competition Commission of India is check that whether the amalgamation will lead into any adverse competition in the market or not. In recent case, Air India and Vistara, the concern of Competition Commission of India that the proposed merger, the merger will result into potential reduction in the flight availability, leading to rise in fares for the air traveler. So after this observation of Competition Commission of Air India, Competition Commission of India, Air India has given an undertaking that on a specific route they will maintain minimum capacity of a specific domestic and international flight, and then after that undertaking, CCI has given the approval. So, and now as I told you that stamp duty aspects is one of the major hurdle, or rather I would say deal breaking in the while we are planning merger amalgamation. So I will discuss this separately on next slide. So please move on next slide. So stamp duty may be a gray area among the corporates that, but there is no confusion on imposing the stamp duty on the revenue side. They have clear picture of it. If I will talk about impact of stamp duty or stamp duty provision in Delhi NCR, basically in the state of Delhi. So only the matter which is sub judice is the merger. In case of merger between holding and wholly owned subsidiary company, whether stamp duty liability will occur or not, it is sub judice. Rest all other transaction of merger demerger, they have crystal clear view that yes, we will charge stamp duty on it. So there is a small story case law which I'm going to discuss, that in the state of Delhi there is one notification 16 January 1937, and there is another notification 25th December 1937. So 16 December and 16 January and 25th December, both notification were same. Basically 25th December 1937 replaced 16th January 1937 notification. Later on, after Delhi Tower judgment, Revenue Department, what Revenue Department did, that they have issued notification in which they have mentioned that now we are withdrawing the notification of 16 January 1937, which was already replaced by the notification number 25th January 1937. And after that, when on the merger of holding and wholly owned subsidiary company, they have issued notification, stamp duty notice. So some company has challenged it before Delhi High Court, and it is still sub judice. Rest all other case like merger, amalgamation, demerger, they are issuing the notice of 3% on the consideration. They are determining the consideration on the basis of issuance of share and the fair value of transferee company shares, and 3% on the consideration and 3% plus 1% registration charge in case of transfer of property. So what I would like to say that there are two sets of state. One where there is a specific provision, rather I would say three sets of state. One, there is a provision specifically mentioned the stamp duty provision, that in case of merger amalgamation there will be stamp duty liability. One state where there is no any kind of provision, law is silent. In one state like Delhi, which provide that, which is relying on the basis of judicial precedent, like in Delhi after Delhi Tower judgment, stamp Revenue Department has issued notice. So the state where clearly Schedule 1A has been amended and it's provide that in case of merger amalgamation there will be stamp duty. So rates has been specified, so there is no confusion. In a state where there is no provision in the law, they are relying on the judicial precedent, and they used to charge on the basis of conveyance rate. So there are 8-9 states like Gujarat, Rajasthan, West Bengal, Madhya Pradesh, Please move next slide. Mumbai. So these are the state where specific provision has been given about rate, stamp duty. So now please move next slide. Move further. Move further. So if we will see the process of restructuring, merger amalgamation, basically under Companies Act, as I told that we will discuss separately about the procedural aspect. So first, while we are planning for any kind of merger amalgamation, so first discussion and finalization of a scheme of arrangement, valuation, other documents. Then we put this document before the approval of board for their approval. After the approval of board, we used to file the first motion application before NCLT. In case there is no mandatory provision in the law in the Companies Act which provide that shareholder dispensation. However, there is a provision that when creditors will give the consent with 90% in the term of 90% value, then NCLT may dispense the meeting. In many cases, we have seen that NCLT has dispensed the meeting. If shareholders has given the consent with 90% or more majority, then NCLT has dispensed the case meeting. But in many cases, NCLT has not dispensed the meeting because NCLT has said that no, there is no clear provision in the Companies Act, so we will not dispense. Once the we will file the first motion application, and NCLT will give the direction to convene the meeting. After convening the meeting, in meeting majority of number and 3/4 in the value, shareholders or creditors, if the case may be, will approve the scheme of arrangement. Then we will file the first. It will be considered that the scheme has been approved by them. Then within the 7 days of meeting, usually chairman file the chairman report. One of the most important aspects which I would like to mention here, that in many cases which we have dealt in past, we have felt that if the transferee company and transferred company having different jurisdiction of NCLT, then transferred company may file the application before principal bench to club the transferred company application before the NCLT where transferee application is pending. So it may save our substantial time. So once the meeting has been convened and shareholder creditors approve the scheme of arrangement after filing of chairman report, the company has to file second motion petition within 7 days. Then after filing of second motion petition, NCLT will give the direction to issue notice to RD, OL, ROC, income tax. And generally in law, as Sethi sir told us, that law provides 30-day timeline, but most of the time opponent means regulator counsel came before NCLT bench and they seek time to submit the report. So it may go longer. So they once they will submit the report, then final hearing will happen, and in final hearing, if all the reports and if they we need to file any rejoinder or any reply, we used to file it, and on final hearing NCLT approved it. After filing of NCLT, once NCLT approved the merger order scheme, and after issuing of order, we have to file NCLT order with registrar of company for registration of sale. Then there are post-merger compliances like consolidation of balance sheet, issuance of share, and stamp duty education. Please move next slide. So in case of listed entity, these are the additional steps which we need to take care. That first board approved the scheme of arrangement. Then we have to intimate stocks in within 30 days of conclusion of the board meeting. Then we need to file the scheme within 15 working days before stock exchange. And once stock exchange will satisfy, yes, that all the criteria which is mentioned in the SEBI Master Circular and ICDR regulations, so it is complied, then they will give the NOC to SEBI, and SEBI will issue its observation letter. And the life of observation letter which SEBI issue through designated stock exchange is only 6 months. If we will exceed the period of 6 months, then we have to again file the application before stock exchange for their approval. Please move next slide. So I believe that it is concluded here.
Thank you, Suman. I think it was a very detailed presentation on how one could do a merger. Almost you have covered everything.
Thank you so much.
So I'll think let's begin the Q&A. I have received some queries online and some were we received before the start of the webinar. So Suman, you will be there for the Q&A?
Yes, sir. Yes, I'm here.
Okay. So I think the first that was posted by Mr. Harshit about merger of a holding company into a subsidiary.
Yeah. So I believe he is talking about the fast track merger, which Suman has discussed. There is a specific provision under the new
Suppose reverse holding into subsidiary.
holding into subsidiary or subsidiary into holding, that is not making any difference. We can have a merger in any way if they are qualifying the conditionalities of section 233, which is the fast track merger route provided under the new Companies Act, Companies Act 2013. Now it is not a new company now, Companies Act. But yes, there is a provision that in case of certain class of companies, which is the small company definition is provided, or in case of merger or amalgamation of holding company and wholly owned subsidiary, it may be in either way, whether merger of holding company into subsidiary or subsidiary company into holding company, or in case of demerger of any of the qualifying company. If all the companies, the party to the scheme, are solvent entities, then they can go for the fast track route, which is available, and under which there is a simplified process, and we have to make a draft scheme which will be placed before the board of directors of the two companies involved, and after that the draft scheme is shared with registrar of companies and official liquidator for their consideration and comments, and 30 days waiting period is there. Post 30 days waiting period, if some comments are coming, we have to incorporate them suitably in the scheme of arrangement, and then file the application to regional director, Ministry of Corporate Affairs, having jurisdiction over the transferee company. So there may be a situation where there are more than one companies having different jurisdictions of regional directors. Then we need not file application everywhere. We need to file the application with the registrar of regional director MCA, which is having jurisdiction over the transferee company or continuing company, and then that regional director is required to pass the order within 60 days. Before passing that order, regional director takes in consideration the observations or objections, if any, of the registrar of company and official liquidator, and sometimes to the income tax department also. And after considering those, they pass the order, and it is the order of RD is considered to be the order of NCLT in the similar fashion. And then the same need to be filed with registrar of company within 30 days next to make the scheme effective. In case the regional directors does not found the scheme suitable for approval, then RD would refer the matter to the National Company Law Tribunal, having jurisdiction over the company, to further consideration. So then the normal process of compromise arrangement as provided under section 230 to 32 would be applicable.
Okay.
I think Harshit has also asked questions relating to reverse merger, right? So the reverse merger, yeah. So I think reverse merger, he is talking about, basically I have asked for clarification, and he said that he is talking about the reverse merger of unlisted company and listed company. So basically, if listed company is getting merged into an unlisted company, that is considered to be a reverse merger. But reverse merger is not a legal term. Sometimes a small company, a big company getting merged into small companies also considered a reverse merger. There may be a situation where loss-making entity is continuing and profit-making company is getting merged into a loss-making entity. All such schemes are considered in normal parlance as a reverse merger. But specifically, if you talk about the merger of unlisted company into unlisted company, there is a specific provision, as Suman was talking about. There is a special rule, Rule 19(2)B of SEBI's, SCRR, Security Contract Regulation Rule, which talks about listing of unlisted company through a scheme of amalgamation. The SEBI in its master circular also provided for the detailed process how to do that, and that is not it is a complicated process, but it is not uncommon. There has been schemes where holding listed company got merged into unlisted subsidiary company, and there are situations where totally unconnected groups are also getting merged. So in that case, if all conditionalities of SEBI security contract regulation rules are getting fulfilled, then post amalgamation unlisted company would be listed directly on the stock exchanges where the listed company were earlier listed. So that is a detailed process. I think that it will be difficult for me to explain everything in this webinar. We can privately discuss with Mr. Hansik on that.
Okay, thank you, Manoj. So I'll come to the other questions that we have received. Either one of you can take it. I think first is the question about seeking clarification on treatment of fractional shares in case of scheme as per the master circular. I think they must be referring the SEBI master circular.
Okay. So
Yeah, so let someone.
basically, a SEBI master circular provide that the fractional shares, consideration for fractional shares should be kept in a trust. And now they have further clarified that we have to mention it in the scheme of arrangement that within 90 days of receiving of consideration in the form of fractional shares, we have to distribute the proceed among the entitled shareholder. So basically, what I was trying to say, that now SEBI master circular provides that we have to mention the treatment of fractional share in the scheme of arrangement itself. And
Okay.
SEBI further clarified that once the consideration in the form of fractional shares in the trust has been received by the trustee, then within 90 days, it must be distributed among the entitled shareholders.
Okay. By way of
So Ankit, let me clarify it further. Earlier, there was no specific provision in case of listed company, but in case of listed company, there may be a lot of fractional entitlements because the shareholding, let's say there is a swap ratio of 5:1, 5 shares against 5 shares of unlisted company, 1 share would be issued, and there are shareholders which are holding less than 5 shares, so they will get fractional shares. Or there may be a shareholder who is getting having 16 shares, and so 6 shares remain as a fraction. So in such cases, there is no whole number. So there were different treatments given by different companies. In some cases, it was seen that they were saying that it will be rounded off to nearest whole number. Sometimes it was said rounded off to the upper higher number. Or sometimes it was said that they will be parked with some trust and liquidated in the market, and the proceeds would be distributed as dividend coupons, right? So now SEBI has clarified that there is no multiple methods, only one method would be applicable, and that is to keep all the fractional shares under one trust and dispose of those shares, consolidated shares, in the capital market within next 90 days by the trustee, and the proceeds must be distributed among the all entitled fractional shareholders. So that is the legal position, right?
Thank you. Next is kindly clarify the class of creditors whose consent is required for obtaining NOC from stock exchanges. In the master circular, it is written that NOC from scheduled commercial banks, financial institutions, and debenture trustee is required.
Yes, so we understand, we know that as per the Companies Act, in case of any scheme of amalgamation, there is a requirement of having a meeting of all class of creditors separately. And in the meeting, it need to be approved by each class of creditors in two methods: simple majority number and 3/4 in value of the persons present and voting in the scheme. However, the SEBI has additionally provided last 2 years back a provision in the Companies Act, the Master Circular for relating to listed company, saying that in case a scheme involves any scheme of involving listed company, before approval of the scheme or no objection from the stock exchange and SEBI, the company need to procure at least 75% of the in the value term of the creditors, no objection. They clarified that it will be the three class of creditors: commercial scheduled commercial banks, financial institutions, and debenture trustee in case company have debentures. So they will be consolidated basis considered to be the total debt, and out of that 75% need to give no objection. Then only SEBI will give their no objection to the scheme.
Okay. So next is, if secured creditors give their consent at the stage of obtaining NOC from stock exchange, whether consent is again required at the time of filing application to NCLT?
Yes, because there is a specific provision in the Companies Act. In case we need exemption from the meeting of creditors during the NCLT process, a specific approval NOC is required from all the 90% in value term creditors, that too in the form of affidavit. Whereas SEBI does not press upon the affidavit in the form consent in the form of affidavit. So there can be plain letter consent at the time of SEBI process. Whereas at the NCLT process, if we need exemption, we need to have consent in the form of affidavit.
So if we take 2 copies of affidavits at the time of the exchange,
Even one copy of affidavit would work. In the beginning, if you got the affidavit in the form consent in the form of affidavit, then that same can be used.
Okay. Can appointed day be futuristic?
Yes, that is very much clear. Even since beginning, there has been cases where future appointed date has been kept. So 2 years back, and Ministry of Corporate Affairs has brought a specific circular relating to appointed date, which says that the appointed date can be 1 year behind the date of approval of the board meeting, or 1 year future, or it may be linked to certain event, which is maybe a future event, like some transaction is closing, then closing date would be considered to be the appointed date. So that kind of flexibility is given. So that is just a clarification given by the Ministry of Corporate Affairs. But legally, there is no bar. It can be any transfer date.
Suman, in case all companies have registered office in Delhi, but have factory and functional units in Haryana. So in case of merger, will there be dual stamp duty? One is on merger and then at the time of mutation of the land?
Yes, sir. If the registered office is situated in the state of Delhi, then if NCLT New Delhi passed the order, then we have to pay the stamp duty on consideration. And when we will go for mutation of property from transfer entity to transferee entity, then we have to pay the stamp duty as per the state prevailing.
There will be dual impact.
Yes, dual set of provision may be there. The Haryana may set off the stamp duty liability, which we have already paid in the state of Delhi, but we have to pay.
And what have been the case if the companies were having the registered office in Haryana itself?
If the registered office in the state of Haryana itself and the immovable property involved in the transaction, in the scheme of arrangement, then only in the state of Haryana we have to pay stamp duty, and the specific provision of 1.5% is there. So we have to pay 1.5%.
So then we can shift the office in Haryana and then save the duty.
Yes, many companies are planning.
Okay. Whether it is mandatory to transfer all the assets in the scheme at fair value?
No, there is no such provision. Even in general cases, if it is controlled transaction. If we talk about the company accounting process, there is 2 type of amalgamation. One is pooling of interest method accounting or controlled transaction accounting, where all the companies involved are within the same group and controlled by same group of persons. Here there is no requirement of fair valuation, transfer of at fair valuation. All assets and liability would be transferred at their carrying book value as available in the last audited financials, and the difference would be adjusted in the reserves. In case of purchase method of accounting, or where unconnected entities are involved in the scheme of amalgamation, then there is a specific provision, the purchase method, where assets and liabilities are acquired at their respective agreed value. So it may be fair value, it may be book value also, and the difference would be adjusted in the capital reserve or goodwill, as the case may be.
Okay. In few cases of WS and holding company merger, we have seen that meeting of shareholders and creditors were dispensed with by the NCLT, even when no written consent was obtained. Can this be placed in other simpler matters?
Yes,
Yes.
I think we have applied in a few cases. So this precedent is coming since the High Court resigned when Old Companies Act was there. So in some cases, High Court have allowed this, considering the fact that holding companies having already got 100% control over the assets and liability of the company. So there is no impact on the there is no compromise or arrangement with any of the shareholders or creditors of the holding company. It is only that the creditors of subsidiary company may not have any control or lien over the holding company. So their interest is getting impacted, and their consent may be required, not of the holding company. So dispensation has been given, complete dispensation has been given, and that is going on in many of the cases in NCLT route also.
Even last year we did the case wherein holding company entirely NCLT is given dispensation.
Okay. Pradeep sir, are you there?
Yes, I'm here, please.
Sir, there is also a question whether NCLT is also look into the rationale behind the valuation under a scheme.
Rationale of the valuation. Normally not, but that will all depend upon whether there's any representation to that extent. If suppose there's some third party who's saying that the valuation is not proper, then maybe we might look into it. But other than normal cases, no. I don't think it is being looked into.
Okay. And there is another question, sir. Do you provide any clarity on how reserves are treated generally under the schemes?
Reserves?
Yes.
No. I don't think that is an issue which is being specifically seen.
Okay.
Of course, again, as I told you, if there's any representation coming to us, there's any third party saying that this is a problem here, then we look into it.
Okay.
Yeah. Basically, it depends upon any other third party, suppose a shareholder or any third party is saying that this is a problem here, then we look into that problem.
And the question, sir, which Manoj replied, that in case of a wholly owned subsidiary merger, at times even without the express consent, NCLTs have given a dispensation from the meeting. So what is your view? Should be the case, or we should specifically seek written consent in order to seek dispensation?
I think it's better to seek the written consent. Of
Okay.
course, they're talking about some case laws. Maybe
Yes.
it all depends upon what view the particular bench takes.
Okay, sir. So
Yeah.
as a matter of conservative,
If the consent can be obtained, I think that would be much better.
that would be always right.
Then we can go ahead with the consent. That will be a better alternative.
Okay. Manoj, it is also, I think in case of scheme, it is also mandatory to issue the shares in demat if it's a public company.
There is no specific requirement to issue shares in demat form. However, as per the new law, note share can be transferred in the form in physical form. So if the person is not willing to transfer it but just want to hold it as a asset, as class of asset in its book, then he may not get it dematerialized. It is simply a matter of choice of the shareholder. We cannot compel.
Okay. So I think I have covered all the questions that we have received for the purpose of the webinar. And I think time is also, we have reached the time limit for the webinar too. So I'd like to take this opportunity to thank everyone.
I think Ankit, 2-3 queries are also there.
Okay, let me see. There is, in case of manufacturing industry, valuation is less than carrying value. It's a half-baked question. There is also a question how the transfer ratio is considered. Share transfer ratio is considered.
Share transfer ratio. So in case of any scheme of amalgamation or demerger, there has to be a consideration. So generally, the consideration is in the form of shares issued by the transferee company or the resulting company, as the case may be. And if that is the case, then it is required to have a valuation report of a registered valuer. As per Section 247 of the Companies Act, all valuation for the Companies Act purpose need to be done by a registered valuer, registered with the IBBI. So they will provide a equity swap ratio, which is fair for both sides of the company. So it is a comparable value which is done, and based on that, the value of the transferor company, share swap ratio is provided in terms of number of shares to be issued by the transferee or the resulting company. So that is the method. And I think the second question is incomplete, but he want if the fair valuation is less than the carrying book value, that is internal thing. In case it is unconnected group, we can go for fair valuation and transfer the assets at their carrying book value, fair value as provided by the valuer. That will be a fine. But in case it is a group company merger, amalgamation, then it need to be transferred at their carrying value only. There is no scope, no provision for revaluation or reducing the value of the any plant machinery.
Okay, thank you. Thanks. I think that was the last question that we received. So thank you everyone for joining us today. It was a wonderful session. The wisdom of Mr. Pradeep sir and then Manoj Suman, they all spoke well and shared detailed presentation. And then Mr. Vijay also shared his insight. So we'll meet next week then. Next Friday is the first Friday of the month. And as per the traditional, we hold a recap webinar on that day, recapping the regulatory changes that have been made since our last webinar, first webinar of the month. So we'll see you on coming Friday to discuss those regulatory changes. Till then, take care and thanks for, as always, joining in such good numbers. I hope we live up to your expectations. And in case you have any suggestions, please do let us know by dropping us an email. The presentation copy will be shared to all the participants who have joined us and will also be available on the website of Corporate Professionals. So thank you. Thanks once again. Thanks, Manoj. Thanks, Pradeep sir. Thanks, Suman. Thanks, Pawan sir. Good evening, everyone.
Thank you, everyone. Thank you, sir. Pradeep sir, special thanks to you for spending some time. Thank you very much.
Thank you very much. It has been a good, interesting session. So I was listening to what you were speaking. It was good, very nice. It was instructive for me also. Yes. Thank you.